Hello and welcome. My name is Kate Marand. I'm a program manager at the DC Department of Small and Local Business Development. Today, we are hosting another session in our spring webinar series in May 2024. Keep an eye on that date because we know that information sometimes updates over time. So if you're watching this recording later, this was in May 2024. As part of the series, we are incredibly excited to bring to you a good partner of ours and someone right here from DC, but on a topic that is so important to small businesses on trademarks. I'm going to turn things over to Marissa Terrell so that she can take it away. Thanks
Thanks,
for the opportunity.
Kate. Can you hear me okay? Sounds like yes.
Yes.
So my name is Marisa Terrell, and I'm a native Washingtonian. I grew up in Southeast Washington, and I'm still here in Northeast. I'm working these days as an attorney for the U.S. Patent and Trademark Office. I work in the Trademarks Customer Outreach Office, and I've been working in this space as a trademark attorney for over 20 years as a solo practitioner, in-house counsel consultant for two defense contractors, law school professor at Howard University School of Law, and a government lawyer. So I'm thrilled to be here today to talk to you about my favorite subject, trademarks. So basically, it's my job to teach you about trademarks, what they are, why they are so important, and how the federal registration of your trademark can help you build your business. Now, I know we've kind of got an intimate group today, and we might have some other folks that I don't see, but I'm going to pause and kind of gauge your interest, maybe check in with you periodically to see if you have any questions. Otherwise, we've got a lot to do, so let me get started. So you can access these slides. I'm going to forward them to Kate and her team so that you can access them and have a direct links to some of the resources that I'm going to share at the end. So what are we talking about today? We're going to talk about what a trademark is and how it differs from other intellectual property. We'll talk about the benefits of registering your trademark with us, the U.S. Patent and Trademark Office. We'll talk about how to select a strong trademark that we hope will sail right on through our review process without a hiccup. And we'll walk through that application process. And finally, we'll check in with you and share some resources on where you can go to get some free help. Trademark fundamentals. Now, before we get started, there's one ground rule that I have to share. Although I am an attorney, unfortunately, I'm not your attorney. I represent the government, so I'm not able to give you legal advice and advise you specifically on what to do with your issue. However, there's so many other things we can talk about, and let's get started right now. So, trademarks really are a type of property. Not real property, not personal property, but an intangible property that can be bought and sold. I like to think of trademarks as really one of the easiest ways to distinguish your goods and services in a saturated marketplace. I mean, think about it. If you're a business owner, you most likely sell goods and or services in the marketplace. So take a minute and consider the products you sell or the services you offer. Okay, you got that in your mind? Now, think about those competitors, your competitors. There are a lot of owners that are selling similar goods and services. So, how does a customer tell them apart? Brands. Brands. So, take a look at the brands shown on this slide here. These are what we call traditional trademarks, brand names, logos, and designs. Now, the cool thing about trademarks is that all of these marks are for use in identifying specific goods and services. You might not know that instinctively, but I bet if we drill down on some of these brands, you will begin to see them in this way. So when you see these trademarks, what goods and services do you think about? Let's go through just a few of them. You see this bitten apple here. What do you think about? I'm sure you don't think about food, right? You think about computer goods, computer services, perhaps retail store services, selling those things. You see the scripted wording Coca-Cola. Hey, you might think about soft drinks. You might think of your favorite soft drink. You see this giant M. It's not for my name, Marisa. It is for McDonald's. You think of a specific type of hamburger and shake and fries, okay? All of these brands represent specific goods and services. In fact, you can't have a trademark unless it's being used in commerce when you for selling goods and services. Okay, that's really what their purpose is. Now, what you'll notice in this instance is that all of these trademarks on this screen are black and white. Why are they not in color? Aren't we used to seeing them in color? Well, we're going to talk about that in a minute, but suffice it to say that if you submit an application and you include your trademark in black and white and you don't claim color as a feature of your mark, then guess what? You can use that mark in any color in the marketplace. So that's one way to get more flexibility by submitting a black and white image. So trademarks indicate source. They're really how a customer recognizes your goods and services in the marketplace, but they're also the legal protection for your brand. That means that you can stand on trademark rights in order to like enforce rights. So if you wanted to go after someone for copying your trademark, maybe they're using your mark to identify similar goods and services in the marketplace. Well, you would rely on trademark law to help you with your claim. Okay, so this is trademarks provide a legal protection for your brands, a way for you to enforce your rights. Now, a trademark is very different from a patented invention or a copyrighted creative work. Okay. Um, we don't have a lot of time for me to delve into it, but let me just give you one great example. What if I created a wonderful vacuum cleaner? Okay. This vacuum cleaner has incredible suction. You can use it on wet items or dry items, and it emits a wonderful scent when it's cleaning. What if that was my invention? So, if it was my invention, then maybe I would get a patent on that invention. But what if I wanted to create some advertisement to promote it, right? Maybe created a fantastic image or a commercial or a little jingle or something that I wanted to use with this product, okay? Maybe I would get a copyright on the song, or maybe I get a copyright on the little short um, television clip or video clip. I could get a copyright on that because that was like a creative work in a tangible medium. I could get a copyright. But if I wanted to give it a name, I wanted customers to know that whenever they saw this particular vacuum cleaner, I wanted them to be able to recognize a specific brand name. Well, that brand name, that's what I would trademark. If it was a logo, I would trademark that. I would seek protection under trademark law, and hopefully I will decide to register that trademark with my office, the US Patent and Trademark Office. So, what doesn't a trademark do? We've talked a little bit about what they do, but what don't they do? Well, a couple of things you want to bear in mind. Just because you own a trademark doesn't really mean that you legally own a word or phrase. Really, what you're saying is that I plan to use this trademark to identify specific goods and services that are offered for sale in the marketplace or for use in the marketplace. So you don't really own that, but you do own it in relationship to identify specific goods and services. That's one thing. Second thing is just because you have a trademark doesn't mean you can stop other people from just saying your word or phrase. You can't kind of snag these terms out of the ether and just sort of hold on to them tight. In fact, it works sort of in the reverse. When you have a trademark, other folks will be using your mark, right? Because they might want to call out what kind of goods and services that they want in the marketplace. Okay. So you can't really stop other people from just saying or using your phrase. Another thing you want to bear in mind is people are not going to owe you money just because they say your word and phrase. Really, the issue of like confusingly similar marks or finding somebody who is using something similar to you, there's a two-part test that you want to use to determine if someone is in fact infringing your trademark, or in fact that there's some sort of likelihood of confusion between your mark and someone else's. We're going to walk all the way through that in just a moment, but I want you to kind of keep these ideas and rules in mind. So the term trademark commonly includes It's commonly used, right, to refer to goods and services these days. But once upon a time, many folks made a distinction between marks that were used to identify services, they called those service marks, and marks that were used to identify goods, they called those trademarks. But these days, we typically use the word trademark to refer to marks that identify goods and or services. Okay? Sometimes we go even make that even shorter and just say mark instead of trademark. So traditionally, trademarks included words, slogans, and logos. These are what we call traditional marks. Let me show you some examples. These are all trademarks for Coca-Cola, and they're all used to identify beverages, right? Soft drinks. A specific type of soft drink. In fact, my favorite type of soft drink, right? We have a word mark, Coca-Cola. We have the slogan, it's the real thing. We have a logo, which is a stylized illustration with wording together, a composite mark. And we have a illustration of the shape of the bottle, just sort of a flat illustration for that bottle. All of these are trademarks that are for use in commerce to identify beverages, and they're all owned by Coca-Cola Incorporated. Notice that these are also in black and white, and so if that owner submitted an application and included these marks in black and white, they would be able to, in practice, in the marketplace, use these marks in any color, okay? Because what they're saying is that they're claiming protection for the trademark uh, in this format with no sort of stylization except for these logos. But when it comes to the wording, no stylization, no specific font, no specific color. And so that means that they have the most flexibility. They can use these marks, these word marks in any color and any font, okay? And these design marks, because they're in black and white, they can use those in any color. Good to know. All right. But what about these? These are really my favorite. These are the non-traditional types of trademarks because if you think about it, a trademark really is can be anything. It can be just about almost anything so long as it is being used to identify specific goods and services in the marketplace. So that means a trademark can be a sound, a color, a scent, a motion, a hologram, a configuration shape. Okay, sound. Okay, one of my favorite TV shows is Law and Order. Okay, I don't care what day it is. If it's on, I kind of feel like I am compelled to watch it, even if it's a rerun. That sound, that dun dun sound, that's a sound mark. That means that it was registered for use in identifying a specific ongoing television series. Okay, that's the trademark. Another sound mark could be the sound that the lifesaver makes. This is for Star Wars. It's like this zoop, zoop kind of sound. That sound is actually a trademark too for use in identifying Halloween costumes and toys for kids. So not just in general does Lucasfilms does not in general own this trademark for any and everything. They own it for use in identifying toys and Halloween costumes. What about scent marks? I love scent marks just because I think they're so much fun. You could think about the smell of Play-Doh. If I don't know for you, it takes me all the way back to Miss Dawkins' class over in Southeast Washington for nursery school. Listen, whenever I would smell that scent, it reminds me of nursery school and how much fun I used to have playing with all my friends in class. Okay, that is a scent mark. It's owned by Hasbro for use in identifying molding clay. Okay, and what about motion marks? Okay, motion marks can even be a video clip. Have you ever gone to the movies and saw an animated movie? In the beginning, what you see are some wordings. I think it's like 5 letters. And then all of a sudden, this lamp jumps up on top of the eye and shines this bright light into the screen. That's Pixar. They have a specific short film that's a motion mark that they've registered with the US Patent and Trademark Office, and they have protection for use in identifying animated films. Okay. Holograms, every time you pick up an American Express card, you see specific holograms on them, specific to American Express, and configuration marks. Believe it or not, okay, the shape of your product can actually be a trademark. You think of the Coca-Cola bottle, you think of the Hershey's Kiss, the way it's shaped. You don't even have to have any wording on it. You already know it's coming from Hershey's, and that is their chocolate. Okay, no one else can use that shape for chocolate because they have a registered trademark with it. Well, I wouldn't say that. I would say folks can do what they want, but they would be violating Hershey's registered trademark if they were to do that. Okay, so we've gone through a number of different marks. I don't know if I did color, but I'll just say really quickly, the Louboutin shoe, we know that red bottom sole, that red color. You see that on the bottom of a shoe, you know it's coming from Christian Louboutin. You see a robin's egg blue box under the Christmas tree. You already are excited thinking this might be from Tiffany's. Okay, they have that color blue associated with jewelry. That is their registered trademark. Okay, let's keep going and let's do a little pop quiz for you. I want to make sure that you're hanging in here with me. I've got my chat thread open and I just want to see if you're saying yes or no. Here's the question. Does a federally registered trademark mean that you own a specific word or phrase? What do you think? Tick tock. What do you think? Got a lot of no's in there. That's right. So just because you have a federally registered trademark doesn't mean you own the word or phrase. Okay. Next one. Do you have to use your business name as a trademark? What do you think? We haven't really talked about this, but I'm just going to throw it out here. Do you have to? I see some no's. Right. You don't have to. Some people do use their trade name or their business name as their trademark, but you don't have to. We know that a trade name or a business name is the name that you register with your state in order to establish your business. Sometimes those names are kind of, well, they're not very exciting sometimes. Sometimes they've got LLC or INC at the end. And sometimes the owner decides that, they want something a little bit more creative, something that they really think is going to spark a customer's imagination. And so they might decide to register a trademark with the U.S. Patent and Trademark Office and to obtain some federal rights in their trademark. Okay, so not the same thing. It's something that it could be the same, but not always. Okay, I know that we've got a lot to talk about, and it looks like there's a few questions in here. I'm going to keep going, and then I'm going to pause again just to check in with you. But let me plow through some of these benefits and then break for questions, and then we'll come back. Okay. So here, let's talk about some of the benefits of registering your trademark with my office, the U.S. Patent and Trademark Office. All right. So let me lay down a bit of a foundation of the rules. Okay. Trademark rights can be really created in a couple of ways. You can create trademark rights through common law, and that means based on how you're using your mark, okay? You can register your trademark with your state, okay? And you can get certain state rights for doing that. And you can also register your trademark with the U.S. Patent and Trademark Office and obtain federal protection, okay? Let's talk a little bit about what we mean by common law trademark rights. So in this instance, when you decide to register your mark with us, it really is up to you to do. There's no official mandate that requires that you do that. But in the United States, it's the first to use the mark in commerce that will always have superior rights. Now, common law rights are based on use, and they can be very powerful. So it means that if you come up with a name, brand name, slogan, image that you want to associate with goods and services that you are offering for use in commerce, well, at that point, you've got a trademark. You've got a trademark that's based on common law rights. But the caveat here is that when your trademark is based on common law rights, there are some limitations. What I mean by that is that you would be limited to having protection in the geographic area where your mark is used. So that means if you're selling candles at Eastern Market, okay, You're selling candles on the Eastern Market. You're calling these candles butterfly candles. That's your brand. And you're only selling them in Eastern Market. Well, as soon as you put that trademark, that butterfly mark on those candles, and you offer them for sale at the Eastern Market, at that point, you've got some use. At that point, your trademark rights attached because there's use there, and now you've got common law trademark rights. All right, but you're limited to the DC area. You don't have nationwide protection. And so that's why some folks might decide to register their trademark with us. Because when you register your trademark with the U.S. Patent and Trademark Office, well, you get nationwide protection. That's one of the benefits. What are the symbols that you can use if you're basing your rights on common law? You can use the TM superscript or the SM superscript. Now, remember, I was saying that the TM stands for trademark, and trademark is typically used to, if you're offering goods and you're using a mark to identify the goods that you're offering in the marketplace. But the SM can be used if you're offering services. But remember what I was saying about how words kind of change these days. The TM can be used for both. Up to you. One thing you don't want to do, though, is if you have not registered your mark with our office, you are not uh, allowed to use that R in the circle. That's not a symbol that's up for you to use at that point. That R in the circle is reserved for those who have filed their application with our office and the mark has been registered. So as soon as your mark is registered, it has gone through our application process, that's when you could use that R in the circle. So let's talk about some of the other kind of rules of the game for when you are obtaining these federal registration rights. What does it mean? So when you're thinking about wanting to obtain federal registration rights, we understand that those rights start once you have registered your mark. Okay, you obtain federal registration after you filed your application and it's been approved in the office, the U.S. Patent and Trademark Office. We know also that as soon as you have a federal registration, that all of a sudden you can stand up tall, right? You have a legal presumption that you own this mark. You have a presumption that the mark is valid. And so if someone wants to challenge you, they can, but you're starting at a higher place. Okay, that's a good thing. Another thing is that when you have a mark that has been registered with the office, you now can use that trademark in all 50 states and U.S. territories. Your protection has now expanded beyond the geographic area where you're using your mark to all over the country, all over the United States. And you can also say, when you have obtained your federal registration of your trademark, well, you can also say that I have now put folks on notice that I have this trademark. Now, how can you do that? Did you know that when you file your application with the office and it is reviewed by an examining attorney, well, there's a point in that application process where your trademark, if it's approved, if there are no issues, okay, if the examining attorney has found no issues to kind of hold it up, then it's approved for publication. And when your mark is published, it appears in this official gazette. This is a website where folks all over the world monitor to see what type of U.S. trademarks that are registered are coming down the pike. Okay. And this is a chance for folks to object. They have 30 days to oppose or you could someone could raise their hand and say, wait a minute, this mark is too similar to mine, too confusingly similar. They have a period. But after that 30-day period, well, then you're able to move on to registration if there are no other issues. Just the fact that we have this process, once your mark is registered, you can actually confidently say, I did put the world on notice. If you were interested in knowing anything about trademarks and which ones are registered, you could have gone to look at this official gazette. So that's also something that you can say. All right. So, what are some of the other rights and benefits that you get from registering your mark with us? Well, you can bring an action in a federal court instead of a state court. You can record your federal registration with U.S. Customs and Border Protection. Now, this is a great way to stop the importation of counterfeit goods. So, if you are in the business of selling goods that are constantly being counterfeited, knocked off, like handbags, pharmaceuticals, airplane parts, sneakers, so many different things. Well, you can list your registered trademark with this office, Customs and Border Protection, and they'll be on the lookout for any goods coming across the U.S. borders that bear your mark, and they'll be looking to see if they actually originated with you or someone else. If they find that they're counterfeit, they will seize them. Another thing, another great benefit is that you can use your U.S. trademark registration and trademark application as a basis for filing your trademark application in other countries. What we know about trademarks is that every different country has their own rules and regulations. And so that means that just because you have a valid trademark in the United States doesn't mean it's a valid, respected trademark in China or in the UK, right? And so you might consider, if you are offering goods for sale overseas, you might consider trying to obtain protection in other countries. Well, there's a process to do that. We have what's called the Madrid Protocol, which is a treaty with 130 countries, and you're able to file an application with us or obtain a registration through us and leverage this Madrid protocol so that you can begin the application process in these other countries. Of course, there's some additional money and of course, there's some additional paperwork, but it's nice to have a one-stop shop of where you can start this process. What kind of symbol can you use when your trademark registers with us? Well, of course, you get to use that R in the circle. Here's another knowledge check. Are you required to register your trademark with the U.S. Patent and Trademark Office? What do you think? Are you required to do that? Let's see what you're saying. Let me scroll down. No, thank you. Yeah, you don't. Federal registration is a choice. Many trademark owners apply for federal registration. However, because of the nationwide rights that federal registration provides. Let me see if I can say that again. People like the federal registration benefits because they obtain nationwide protection for their mark, and that's a benefit that many folks like, and that's why they take the time to register their trademark with us. Okay, here's another one. Does registering your trademark with the USPTO give you international protection? Thank you, folks, for answering. No, registering your trademark with the U.S. Patent and Trademark Office only provides rights in the United States and its territories. Okay, let's pause right here, and I'm going to check in. Are there any questions? Is it okay if I slip in here and look at some of these? I'll just pick a few and just kind of ask. I see something from Dr. Kita. She says, can you sign up for the Madrid Treaty at any time? Yes, you may. You can sign up for the Madrid Treaty. Um, it's usually folks usually do it leveraging their application and using it to leverage their registration. What I can do to make sure that I answer that correctly is I want you to take a moment and go to our website, uspto.gov, put in Madrid Treaty, or put in Madrid Protocol. You're going to find an entire website dedicated just to answering these questions, and there's about 20 FAQs on that page. Frequently asked questions are where you can go to get that information. And I'll just do one more. So a trademark or a service mark is not or is a paid service. So if you are using the TM or the SM superscript, you really are leveraging common law rights, right? You are saying that you have a trademark and you are basing your trademark on common law rights, not federal rights. So common law rights, there really is no cost associated with that because you obtain those common law rights just based on using your trademark in your geographic area. But if you want to obtain federal rights, well, there's a little money involved with that, and we'll talk about that in just a moment. Let's keep going. Selecting your trademark. As we move through the next few slides, there's a couple of things I want you to bear in mind, okay? Remember this, our goal is to register trademarks, and your goal is really to select a mark that's both federally registrable and legally protectable. Because really, not every trademark is enforceable. Now, that might sound strange, but let me see if I can give you an example. All right, picture this. 1853. All right. 1853. This is a hypothetical. This is not a true story. I want to give you a hypothetical just so I can reinforce some of these rules. So let's just say in 1853, there's a company that makes jeans, okay? And they've recently celebrated their 200th year. This company sells jeans under the brand name Butterfly. Can you tell I like butterflies? I use it a lot. So Butterfly is the brand of jeans that they're selling, okay? Now this particular company never decided to register the trademark with my office. In fact, they just operated under common law since 1853. And during that time, they hit a lot of states, meaning they sold these jeans in a lot of states. There was some commerce that was established in a lot of different states. Maybe they even sold on the internet and got a lot of sort of use in that manner. Then let's say that in 2023, there's a competitor that pops up. Okay, so this is like 200 years later, a competitor comes up and has this great idea that they want to file an application and register a trademark, Butterfly, for use in selling jeans. Okay, now, what's interesting is that if they file their application with the USPTO and an examining attorney pulls that record and conducts their search, when they conduct their search, they will not find Butterfly. They won't find that company that's been using Butterfly to identify genes for the last 200 years because that company never applied for a mark with the USPTO and never obtained a registration. Remember, our database only consists of marks that have been applied for or registered, okay? So in that instance, the competitor's application could conceivably be approved. If there are no other issues with it, if the search didn't reveal anybody else that was problematic, confusingly similar, it's possible that their trademark application could be approved, okay? So if that happens, what does that original owner do? In this instance, in actuality, the company, this competitor who tried to obtain a registration, it's unlikely that they're going to be able to enforce it. And the reason why is that the company that has been operating for 200 years has prior use. They've been using their mark longer. Now the challenge is that company that has been around for 200 years will have to prove that. They won't have prima facie evidence that they have a legal presumption or anything that they are the owners of this mark, and so they would have to prove it. That's really the clincher here. So, to make a long story short, you want to make sure you select a trademark that can go through our registration process and be registered, but that is something that you can protect and enforce against someone else who may or may not have been using this mark. Okay, so some things you want to bear in mind as you select trademarks and as you determine whether you want to register that trademark with the office. Okay, two main concepts I want to run through, and we're about at the midway point. There are two main reasons why your trademark application could be refused, or why your trademark might be refused if you apply through our office. One of the main reasons is that it's likely there's a likelihood of confusion with another mark that was filed before you, that registered before you. Okay. Another issue is that you might have a problem if you select a trademark that's considered weak. Okay, this would be a trademark that is descriptive. So we're going to talk about these two main reasons why your application or your trademark could be refused, in hopes that you may think about this as you're drafting your application, and it'll inform how you apply. So how do you select a mark, and how do you avoid this likelihood of confusion, refusal? So again, one of the most common refusals that we issue is the likelihood of confusion refusal. Basically, the USPTO wants to make sure that consumers are not confused about the source of goods and services. So, what you want to do is you want to look at the marks and you want to look at the goods and services, and then you want to apply a test. This is the test. Asking yourself first, are the trademarks for the two, your mark and a competitor's mark, are they similar? And when I say similar, I'm asking, are they similar in sound, appearance, or meaning? Okay. I'm also asking, are the goods and services related? Now, remember, you need a yes for both of these prongs in order to find that there is a likelihood of confusion. Keep in mind that it is possible that two marks can be identical but have different goods and services that are unrelated. If that happens, they may still be able to coexist as registered marks on our register. How is that? Well, think about it. Let me give you a great example. What about the trademark Dove? Dove for use in identifying soap, Dove for use in identifying ice cream bars. Two identical marks, two registered marks. But because the goods and services are not related, I can't think of any brands that sell soap and ice cream under the same brand elements. I can't think of one. So it would be said that these goods and services, or these goods in this case, are unrelated, and so the test fails. Let's do a couple of examples so that I can reinforce that rule. Here's an example. Let's say that your trademark is T. Markey and you're selling shirts. You file your application, or you want to file your application for this mark for use in identifying shirts. Before you file, you conduct a search because you want to make sure that you don't run into any hurdles, because you know we don't give refunds, all right? So that's your mark. When you conduct your search, you find this other one, T. Markey for pants, and you're asking to yourself, am I going to get a likelihood of confusion refusal? Let me think about this. Let me apply the test. First, are the marks similar in sound, appearance, or meaning? What do you think? Yes. In this instance, these marks are identical. So we can check off that mark. Yes, the marks are similar. Now you're looking at the goods. Are they related? Shirts and pants. Can you think of a lot of different brands that sell shirts and pants under the same brand name, under the same brand logo? I can think of 30, 40, 50. Okay, so many. So yes, it's likely that a refusal is in your future. Right, exactly. Alfonsia, she said, Polo is a great example, okay? That's of a brand that sells shirts and pants under the same branding. So we know that these goods are related. So yes, there's a refusal here. Let's do another one. What about T. Markey for shirts? That's yours. But you find this other one, T. Markey for pants, and you're like, uh-oh, am I going to be in trouble? Is there going to be a refusal that's going to be issued here? Let me think about it. If you're looking at T. Markey and you're looking at T. Markey and you're saying to yourself, are these marks similar? Remember, our test is, are they similar in sound or appearance or meaning? In this instance, they sound the same. So that's enough to say that the marks are similar. Now we're going to look at the goods and we're asking, are these goods related? Well, we just said that they were. So in this instance, again, we have a refusal. Similar in sound and related goods. Okay, last one. Notice what changed here, the goods. T. Markey is your mark for identifying shirts. T. Markey is the competitor's mark that you found when you conducted your search. It's being used to identify golf flags, and you're thinking, oh my goodness, is there some confusion here? Do I think that the examining attorney is going to issue a likelihood of confusion? In this instance, I have to pause. I don't know much about golf. Okay. I'm not a golfer. I can't remember last time I went into a store that sold golf items. So I'm not very familiar with the industry. I'm going to have to do some research. I'm going to have to look up a bunch of different golf companies and see, can I find a couple of brands that sell shirts and golf flags under under the same branding? If I can find some golf flags and golf and shirts under the same branding, then yeah, maybe there might be some confusion here because I could make the argument that these goods are related. If I'm having a hard time finding companies or brands that sell shirts and golf flags under the same branding, then maybe I cannot make an argument that they're related. And so maybe there's no refusal. You see how a lot of this turns on your research and the information that you find. Because once upon a time, it might have been said that um, marks that identify jewelry and marks that identify handbags are very different. But these days, don't can't you think of a lot of companies that sell jewelry and handbags under the same branding? So these days you've got to really do your research to be able to figure out what's happening in the marketplace right now. That's really the beauty of trademarks is that we are really about the now and the zeitgeist. Okay, so how do you determine which marks may be confusingly similar to your mark? You're going to conduct a search. Now, we've got a U.S. Patent and Trademark Office search system that's free. It's available 24/7. It's on our webpage, and it's also references in these materials that I'm going to forward to Kate to share with you. But you want to be sure that when you're conducting your search of even our database, keep in mind that you not only have to search our database to find trademarks that have been applied for and registered with us, you also want to search the internet because you're looking for those butterfly brands, the ones for those companies who never decided to register their trademark with us. You want to find them because if they've been using their mark longer than you have for related goods and services, there may still be some problems with regard to whether there's a potential for infringement. Okay? So, who can do this search for you? Who can conduct a search for you? Well, you can certainly do it yourself. We suggest that perhaps you take advantage of some of our free web uh, videos and handouts that we have navigating through our search system. But you can also hire a private attorney. Now, the benefit of hiring a private attorney is that they can conduct a very comprehensive search for you, which can help lower the risk of later finding out that there is a confusingly similar mark out there that can be maybe problematic. So, where does a trademark attorney search? Their search is going to include the USPTO database of registered marks and marks that have been applied for. You'll be searching state trademark databases, business name registries, foreign trademark databases, and the internet. Let's do one more knowledge check before we move on. What if your mark is X-seed and you're offering agricultural seeds under that brand? And then you did a search, you conducted your own search. You looked in our database, you looked on the internet, you found X seed for live plants. And you're thinking to yourself, now wait a minute, is there going to be a likelihood of confusion refusal in my future? In this instance, I'm looking at these marks and I'm saying, okay, similar in sound, appearance, and meaning. Well, there's a similarity in sound here, and the goods are related. I mean, how many different brands can you think of that sell agricultural seeds and live plants under the same branding, same brand elements? A lot, okay? So here there would be a refusal. So now you have an idea of the test. I'm hoping that you'll be able to apply that going forward, maybe to save yourself from receiving a likelihood of confusion refusal. Okay, let me keep moving because I'm looking at the clock. We have a couple more things to get through before I break for questions. All right, selecting your trademark. Now, remember I said there are two refusals we want to talk about today. We talked about likelihood of confusion. Let's now talk about the strength of a trademark. Let's try to select trademarks that are not descriptive in nature and so are very, very strong. Let's show a couple of examples here. So we know that as you're selecting your trademark, you want to be sure that you can enforce it, right? And so you want to try to avoid using trademarks that don't and cannot indicate where a good or service comes from. These type of marks that are incapable of identifying where a good or service comes from would be considered weak marks. If they're incapable, it's likely that they're going to be generic. But in this instance, if you just think about this, you're going to ask yourself, does any word in your trademark or even an image, does that describe a feature of your goods or services that are offered? If it does, you might consider selecting something else or just bracing yourself because maybe it's descriptive, your mark is descriptive, and it may be more challenging to enforce it or protect. Descriptive marks are those that describe an ingredient of the goods and services, the quality of the goods and services offered, a characteristic, a function, a feature, a purpose, or the use of specific goods and services. If a mark is merely descriptive, it's not functioning as a trademark. So you're going to ask yourself, does this trademark merely describe the goods and services? Let me give you some examples. This infographic right here shows us a range of different types of trademarks. We want to stay in the red zone. Okay, the red zone indicates that these marks are strong, fanciful, arbitrary, suggestive. That would be what you might want to aim for if you want a strong mark that will be easier to protect. Descriptive and generic terms, not so much. Let's kind of get into this a little bit more. Okay, so generic terms are common everyday names for goods and services, right? These marks are not registrable. You think about if you're selling a dairy-based beverage and you want to call it milk, I don't care if it's oat milk, almond milk, or milk from a cow, okay? If you're using milk, that means that everybody in that industry is likewise going to need to use that term. And so milk is incapable of letting a consumer know where your product originates. All right. Generic terms are not even trademarks at all. They even fall below that. And so that's definitely where you want to stay away. If you try to select a generic term, you most certainly will get a refusal. Um, a descriptive trademark, though, would be something that directly describes a feature of the goods and services that you offer. These marks can be registrable, but only on the supplemental register. They're not registrable on our primary register, which is the principal. This is the one that gives you the most protection. You can register them, you may register them over time on the principal register if you're able to establish that your mark has acquired some sort of distinctiveness. Here's a good example. Here, this is a real case where the owner selected the mark Creamy Whip to identify whipped toppings. Now, Creamy Whip was determined to be descriptive because, I mean, isn't all whipped topping creamy and whipped? Okay, yes. But this particular owner was able to establish over time, over 5 years, that they have done so much marketing and have educated their consumers so well that their consumers now see this term and think of them. They think of the source of the goods themselves. But that is a process. Imagine, though, how many cease and desist letters they may have to write, because I could see a lot of folks in their industry who offer some sort of whipped topping wanting to use the word creamy whip to identify the whipped topping. And if they do, well, this particular owner would then have to police their mark. That is a requirement for if you have a trademark. So in this instance, yes, you can maybe sometimes get to obtain trademark protection, federal trademark protection for descriptive terms, but it's a little bit more challenging. Okay. Suggestive trademarks. I like these because they require a little bit more imagination. Suggestive trademarks do just what they say. They suggest a quality of the goods and services. They are registrable. An example would be like copper tone for use in identifying suntan lotion. Okay, that's a good example. You're not exactly going to turn the color of copper. Okay, you're not going to be shiny like a penny per se, but there's some suggestive, there's a bit of suggestive nature of the terms, and so it sort of suggests the quality or what the goods and services are. This is registrable. This is considered a strong mark. Fanciful terms are those that are invented, no meaning at all, super strong. We're thinking of Xerox for photocopiers, Kodak for film, Kleenex for tissues, Pepsi for soft drinks, all inventive words, all registrable words. So you can definitely make up a word if you like. And what about arbitrary terms? Actual words, but no association with the goods and services that are offered underneath them. These are terms you'll find in the dictionary, but they're not commonly associated with these specific goods or services you're offering. They're registrable, okay? You want to think about Apple for computers, the Gap for clothing, BlackBerry for mobile phones, okay? All of these terms are real terms, but they're not commonly associated with those goods and services. Here's another knowledge check for you. Want to make sure you're hanging in here with me. Bicycle for bicycles. This is your mark, okay? You decided that you're going to create these wonderful bicycles and you want to be cool and name your bicycles the brand Bicycle. Is that okay? What do you think? And then here's another one. What about selecting the term bicycle for playing cards? Which one of these is registrable? So I see a couple of folks said no and yes, right. So bicycle for bicycles, that's generic. You can't do it. That's going to get you a refusal right away. But bicycle for playing cards, well, that's a registered trademark. That does not describe features of the goods and services. It does not provide the genus of the good. So yes, this is okay. It's actually quite arbitrary, right? Because it's a real term. Bicycle is a real term in the dictionary, but not commonly associated with playing cards. Okay, looking at the time, I want to kind of flow through these here. These are the broad strokes that every application goes through. When I was an examining attorney in the office, I would get an application. First thing I'm going to do is review it, do my search. Then I'm going to run through my checklist to see if there are any reasons why I need to refuse it. That's the examination process. If I find no issues, I'm going to publish it in the official gazette. If no one opposes it, it's going to move on to registration. But remember, not every trademark registers, okay? You got to be sure that you're selecting a mark that's going to sail through our application process. And hopefully this video is going to help you begin to think about some of the common ways that your trademark application can be derailed. Now, some folks want to know basically, okay, I've heard everything you've said. How much is this going to cost me? Let's talk about that, okay? When you file your application, you're going to use our online system that we are working to improve. Soon there'll be a new one, okay? But for right now, you're going to use our TEAS, our TEAS form. Now, we charge the fees based on the number of classes in your application. So let's go back to our butterfly brand, right? Let's say you're this company and you're selling jeans under this butterfly brand. Well, our office classifies goods and services in numerical classes 1 to 45. And what that means is whatever class the goods and services that you offer fall in will let us know how much money to charge you. Okay. So if I'm a fashion company and I'm selling butterfly jeans, well, jeans are classified in 25 along with shoes. So that's one class. If I'm selling sunglasses, that's in class 9. So now I'm up to 2 classes. And if I'm selling some jewelry, I'm in class 14. I'm at 3. Perfume, class 3. I'm at 4 classes. And what if I want protection of my trademark for use in identifying an online retail store? Well, that's class 35. That's 5 classes. You can choose the option of a $250 per class fee or a $350 per class fee. The $250 option is lower because you're required to select pre-approved wording. What I mean by that is we have what's called an ID manual. You can take whatever term that describes the goods and services that you're offering, put it into this database, and the database will let you know what class it's in, and that will help you determine how much money it's going to cost, okay? We know that the total fee is determined by how many classes you include in your application. Now, what are the requirements? Very simple, but I would caution you that within each one of these simple requirements, there are a lot of legal issues. So you want to be sure to give us a clear depiction of your trademark. Notice I said depiction and not drawing because I know that gets confusing. Give us a clean JPEG image, okay, of your logo. Or if you want standard characters, meaning you don't want any color or any font, you just want the wording to be protected. Just type in the wording in a little box that we have in the application, and then you'll have, if you get registered, you'll be able to use it in any color or size and any font, okay? You want to give us your listing of goods and services. Remember, when you select a trademark, you've got to tell us exactly what you'll be using that mark to identify what goods, what services. Give us the basis. Are you using your mark right now, or are you intending to do so in the future? Your contact information, an email, because that's how we correspond, and don't forget the money. We've talked a little bit about some refusals. There's a couple more here. You can simply put these key terms into our search system, meaning onto our website, and that will provide you with more information about some of these other refusals. But I'm looking at the clock. I want to be sure that we can get done with this. Please be mindful that it's up to you to police your mark. Our office is not an enforcement agency. We simply register trademarks, okay? It's up to you to police your mark, to use your registration that we issue to go after any bad actors who might be infringing your mark, okay? And here's some good news. Trademark rights will last forever as long as you renew them, okay? You want to renew them uh, 5 years after your mark registers. So your mark registers here, count 5 years into the future, renewal. You're going to pay some fees. You're going to provide some evidence that you're using your mark. And then again, 10 years later, from the day of registration, 10 years, okay? And then every 10 years, if you file these fees and you file these renewal documents, your trademark can last in perpetuity. That's more than patents, more than copyrights, okay? So that's one of the great benefits of trademark rights, federal registration, federally registering your trademark with us. Okay, last knowledge check. Are you guaranteed registration of your trademark? What do you think? Nope. Nothing's guaranteed. What's guaranteed, right? No. So if any third party bad actor comes to you and says, I can guarantee to get your trademark registers, mm-mm. That's not possible. All of this is based on case law, and case law changes all the time. So it's important to know the rules, and that's why it's a good idea to get a lawyer to file it for you. Be mindful that having a paralegal file this trademark for you is not acceptable. That's not something you can do. You can file it yourself, or you can hire a lawyer to help you. Okay. And here we go. If your trademark registers, do you have to do anything to keep your registration alive? What do you think? What do you have to do? You've got to pay some more money 5 years after it registers, 10 years after it registers, and on and on and on. Okay? Pay some more money, file some evidence of use documents, and then you can have a trademark that lasts forever. The how to find help. We've got a problem with scams right now. What I mean by that is that as soon as you file your application with us, your email is available to the public. You're going to get a ton of solicitations from third parties who are going to be like, hey, let me help you with your trademark. Hey, did you know your trademark's about to expire? Hey, don't panic. If you ever receive something in the mail and you're wondering, what am I supposed to do with this? I invite you to call our Trademark Assistance Center. I'm going to put the number up right now, right here, 1-800-786-9199. Call this number, speak to a live person from 8:30 in the morning Eastern Time to 8 p.m. at night. Tell them you got some kind of crazy correspondence. You want to know if this is real. Please know the USPTO does never ask you for money over the phone. We don't take Cash App or PayPal. You can only pay through our interface. And if you ever have a question about whether some correspondence is legitimate, call this office and they will direct you to a place on our website where you can see every document that's in your file. Every document that's been issued by our office is available for you to view on our webpage. Okay, and with that, I'm going to stop right here. I have taken up this entire hour. I wanted so much to show, to answer some questions. Kate, I don't know if we have any time for that, but I'm available.
I'm happy to stick around, and as folks are able to stick around, and I'll mention one thing off the top. I do have all the questions here, and I can kind of repost them in the chat. They're all numbered. But I will mention we did get a couple of questions about patent and copyright. Those are different areas of law. One of the things that I will share in the chat as we start getting through those questions for everybody else is also some information about connecting with the DC Bar Pro Bono Center, where you can work with a volunteer attorney. It's a great follow-up, both for questions or if you're moving forward. But Marisa, I'm just going to start posting these questions back in the chat. They're numbered, so you can look.
Okay. Okay, super. Okay. Oh, thank you. Okay, let me go back up.
Yep.
Okay, first question. I understand the dimensions of a logo and tagging product before submission to trademark. However, I don't know if there's a way to check for similar images and not just the availability of the brand name. What should be my proper steps? Okay, I want to show you quickly because I know we don't have a ton of time, but let's look at this. This is our website here. Okay, well, I'm sorry, that's our internal website. Here's the external website. If you want to search, you're going to go to our USPTO.gov. You're going to go to trademarks and you're going to hover over application process, search our trademark database. Don't worry, I'm going to give you the link. But what I want to show you really is when you get to this page, see our trademark search system updates page. Here you're going to see some videos on searching. Videos here and some handouts that give you some cheat sheets on how to navigate the system. If I was to go in here to search and open up our system, and I was to go to expert mode, you must be in expert mode to search design. I go down to design code, that's what I have to use. I go to design code manual. You're going to have a recording so you'll be able to see this. Type it in. What if I wanted to search butterflies? That's my logo. I type it in. I get a numerical code. I copy it. I go back to my search page. Where did it go? Mm, mm, mm. All right, let's start again. Not patents, trademarks. Okay, I'm back at design code. I'm on expert. Got to be an expert. Putting my design code in there in expert and I search. That is how I search design in our system. Okay, it's a couple of steps there. You have to go get the code, put it into the design code. When you go to the videos, I would suggest you watch the second one on field tag searching because you're going to see that when you're searching design codes, there's some other tips that you need to keep in mind to do an effective one. Okay. Next question. Along with the actual logo, can the company name and mantra be included? Absolutely. You can look at some of these. Look at these trademarks here. This one's registered. You see it has a design and wording. So you absolutely can submit one JPEG image of one composite mark seeking trademark protection, federal trademark protection for a design. You would just simply upload one JPEG that has all of that stuff mashed together, right, as one image, and that's what you would submit. 3, our phrase is non-trademarkable. Just do it. Just do it is registered. So for example, if I wanted to find that, I could go, I have to be an expert because I'm looking for multiple terms. I'd be looking for just, you have to use this, do it. Okay, searching that. And I see Just Do It owned by Nike. You can see this one was canceled. This one is pending. That one's abandoned. Is there a registered mark? Here it is. Here's one. Just Do It, pending, pending. Here's one registered. Just Do It. Registered mark for clothing. Okay, they have this protection for clothing, and that is their slogan. Just Do It is a word mark, and they even have the period at the end added to their mark. Okay, can I place things on a t-shirt without infringement? Well, that's a loaded question. You can certainly put anything you want on a t-shirt. There's a couple of issues you want to bear in mind. Infringement is one because whatever, remember you have to apply that test. Whatever that whatever that trademark is on the front, you would want to conduct a search of it to see if there's someone else using that same trademark in a related for related goods or services. That's one. But you'll also notice that when it comes to t-shirts, there's another common refusal that you want to bear in mind. There's what is called an ornamental refusal. What that means is whenever you file your application with the office, before you can obtain a registration, you have to provide evidence that shows how your mark is used in commerce. Typically, for t shirts, folks just want to provide a photograph of the t shirt with the logo right on the front. If you do that, it's most likely you're going to get an ornamental refusal. Because where does a customer look to find out who made a t shirt? They don't generally look to the front. They look to the tag in the back. They look to a hang tag on it or something, or maybe the packaging that the shirt arrived in to let them know that where the shirt came from. That's where the logo needs to be or the trademark needs to be in order to signify trademark use. Okay, so there's two issues you want to be on the lookout. Number 5, to clarify, can I trademark my logo and name if my actual sample product has color within the logo? Can I submit a black and white photo or logo along with the sample product? So if you're trying to obtain federal trademark protection for a logo, and you only want to use it in specific colors, like McDonald's, they might only want protection for that giant M in yellow. If they don't want protection in any other color, they would need to submit a yellow JPEG, meaning a JPEG that has the M in yellow. And that would mean that they would get protection for that M in the color yellow. If they decide to, maybe they say they don't care. It could be yellow, it could be green. They don't have any preference. They may use it in yellow, they may not. They might use it in red. If that's the case, and yellow is not really, they're not wedded to that color. In fact, they don't need to have protection in one specific color. Well, they can upload a black and white JPEG. And if they do that, they can use that mark in commerce in any color. So when it comes to the evidence that you want to submit, if you uploaded your mark in color and you're claiming color is important to you, well, your specimen needs to show color. Okay. If you upload your trademark, your JPEG in black and white, meaning color's not important to you, well, your specimen or your evidence can show your logo in any color. You see what I mean? A little bit of flexibility there. And I think that's it.
Oh, we got a whole other set. If you
Oh,
scroll
there's
down
some
just a
more.
little bit,
Okay.
it just didn't all fit in the paste.
Oh, sure.
The
Does
signature
common
ones.
law include the older way of mailing it to yourself and not opening it? Does this give you rights or just a fiction? I think you're talking about copyright. Mailing it to yourself was like sort of this old idea of sort of giving you a date stamp. But think about it. For trademarks, your rights attach under common law as soon as you begin to use your mark in commerce to identify specific goods and services. So, if you start using your butterfly brand to identify candles, the first time you started doing that and you offered it for sale in a marketplace or something, you've got some use in commerce. At that point, you've got common law rights. All right. Now, how are you going to prove that you have common law rights? Well, now you got to start thinking, do I need to have something notarized? I mean, what would be stand up in a court of law if someone challenged me? That's where your brain starts working. And so maybe you want to mail it to yourself. You got to think about, could that be challenged? Maybe I need to frame the first receipt of sale. I don't know. Or you could just file your registration with the United States Patent and Trademark Office, and that becomes the presumption that you are the rightful owner of that mark. And now you don't have to be worried about trying to prove when this happened per se. Okay. That's another way. So, yes, I can see some people might be thinking about that, but just think about, are there ways that someone else, a competitor, could put some holes in that envelope? Meaning, like, could they challenge that in some way? You're trying to think of ways where you can evidence of what your first use in commerce date is, because in the United States, it's the date of first use is when your rights for trademark attach. Okay. So you have to be able to justify and to know that in case you get challenged. Here's a question. So TM or SM is not or is a paid service? Answered. Okay. Would those common law rights also include the internet use of a trademark until it's registered with the USPTO? Remember, you have to think about your trademark rights as not just internet use. Was the trademark used to identify specific goods and services offered for sale on the internet? Maybe then you might be able to say, yes, there's some use in commerce there, but it's not just putting it on the internet. It's got to be used to identify goods and services. I don't know if you remember when Cardi B tried to register that sound. Oh, remember she tried to register that sound? She had some difficulty because although she was using that sound, everybody knew that she used that sound. It was everywhere. But was she using that sound to identify a specific product, a specific service that she was offering? Until you are offering a product or a service, there is no trademark right. Okay, so it's not just putting it on the internet. There has to be some identification. It has to be tied to goods and services offered for use and offered in commerce. Okay. Can you sign up for the Madrid Treaty at any time during the journey? Okay. Sort of answered. That's a little bit out of my depth to know specifically when, but I know that as an examining attorney, that did happen. Those applications coming through on my desk, you based on the registration, based on an application, but there is a specific website that you can go through. Go ahead and type in Madrid Protocol in USPTO.gov and go to that FAQ page. And then here we go. How can I go to register my trademark? Um, so if you want to register a trademark, that's all we've been talking about today. You want to first be able to navigate to our application. To register a trademark, I would suggest you conduct a preliminary search first just to make sure that that it's clear that you're not going to run into a confusingly similar situation where your mark might be refused because we don't issue refunds, okay? As soon as you apply, you're really paying for the time of an examining attorney to review your trademark. Once you do that, you can simply fill out the application. We have what's called the Trademark Basics Boot Camp. Let me see if I can go back on my slide deck to show you this. This Trademark Basics Boot Camp is an 8-module course. There's one section of that module. It's called an application filing walkthrough. And we will actually walk you through an application, meaning we'll have it up and we will fill out the blanks with you. So that might be something you might want to consider joining us for. If you go to the USPTO.gov and you put in Trademark Basics Bootcamp in our search bar, it will pull up the next scheduled time that we're going to do that. We're running into Module 8 on Tuesday. They're offered typically on Tuesdays between 2 and 3:30. But our schedule, if you go to our website, you'll see our whole schedule. Each one of the 8 modules, sometimes I'm running them, sometimes my manager's running them, or my colleagues, but there's always somebody there who can answer questions at the end of that presentation. We really do save 30 minutes for question and answers, and we do a live chat where you can put in a question, and we got experts from the office to answer your questions in real time. Okay. I'm sure that you're going to speak about patents, but I'm being proactive in my questioning. I have a patent through the USPTO. Are you able to type in my name and patent title and find it? I'm away from my patent now, and I don't obtain any funds for research and development. Unfortunately, I'm not a patent attorney, okay, and nor am I a patent examiner. This is a trademark discussion, and trademarks and patents, although they're both intellectual property, examples, they're very different. So if you want some information about patents, we have a program called the Path to a Patent, a series of videos that show you how to search, how to use their search system, how to navigate that. Put a pathway to a patent into our search engine, and it'll take you to that page where you can find out some information. We also have a patent pro bono program if you're looking for some free services. Um, to help you with your patent, you can go there. There's also law clinics in the area. I know that I used to manage the clinic at Howard University School of Law. They've got a patent and a trademark clinic, so you can contact them. I think Daryl Motley is the attorney over there who's on the patent side. You can contact him, Howard University School of Law. Find that by going and putting law school clinic in our search bar to pull that up, okay? If I have a trademark in DC, do I have to get one from the USPTO? Well, you don't have to, but think of all the benefits that you'll miss out on if you don't register your trademark with us. If you don't register your trademark with us, you're operating under state law. If you're saying you obtain a trademark, well, now wait a minute, let me pause. DC is quasi federal. So there are some specific rights that you obtain because DC is kind of federal. I do not. Now that is a whole can. I'm not
Yeah,
going to get into, but I'll just say that you have some more benefits if you decide to run that or register that trademark with us at the U.S. Patent and Trademark Office.
can I jump in with a quick
Please.
clarification?
Yes.
So the registration from the District of Columbia is a trade name
Mm.
registration.
Hmm.
It's not typically a mark.
Right. No.
So it might be a name, but it's a name in use or commerce, and you would do that through the Department of Licensing and Consumer Protection. It does only give you protection in DC, and it only gives you protection for the name. So they are a slightly different protection.
Okay, so trade name registration, we know that really is just registering your name with the state so that you can transact business here. And even though DC is not a state yet, right? You put, you do obtain some trade name protection. Now, with regard to trademarking, I'll have to defer to what Kate is saying because I've not researched that issue, but I know that if you want to obtain a wide protection throughout the United States and its territories, consider filing an application with us and registering that same trademark through our system. Okay, and let's see. Is this the same as copyrights? No. Copyright is a completely different intellectual property right. It is managed by our sister agency, the Copyright Office, which is over at the Library of Congress. Basically, think of it like this. If you have a creative idea and you put that idea in a fixed, tangible medium, say you got an idea for a book and you create a book, okay? You can get copyright protection on that book and you can register that copyright with the Copyright Office. You create a sculpture, a painting, music, all of that, you can register that with the Copyright Office and obtain some federal protection. If you don't register it with the Copyright Office, you're not able to even bring a claim against anyone. So it's a good idea to navigate to their website. They've got a ton of videos and other type of resources that are available to help you navigate their process. They have a specific process that's very different from trademark. Trademark is really the brand name, the brand logo, the slogan, the color, the scent, the sound. These are different marks that you're using to help a consumer find you in the marketplace. Instead of saying, "Oh, I'm the one that sells those skateboards," you give them a brand name so that they can find you. I'm looking for skateboards by this particular company. It helps the customer find you. It helps you build goodwill that can follow you. And it's a great way to distinguish yourself in a saturated marketplace.
Yes, thank you. I missed one above, so they did bring it back down. That is, and then we'll wrap up. But I appreciate everyone taking the additional time with all of this. The question is, can I have more than one tagline for a logo?
Absolutely. But remember that unless you are cramming it all into one JPEG image, what you're talking about are several different trademarks. So if you think about Nike, they have trademarked the stylized swoosh and the wording "Just Do It," and they also have a trademark for Nike. They have trademarks for each one of those individual brand elements, and for each one of those elements, they will then be listing the goods and services offered under each. So that sounds like you're offering a couple of different trademarks, and that's okay, but that you want to think about, just be sure that the slogan that you're talking about is being used as a trademark. There is a common refusal for coming up with informational slogans. You might get a refusal if it's something that a consumer is used to seeing, like "I Heart New York." You can't obtain trademark protection on for that slogan or for that slogan because it's something that's informational. Everybody uses "I Heart New York," right? It's not something that someone uses to indicate where goods and services come from. So be careful to trying to obtain perpetual protection over slogans when they're not really used to identify specific goods and services offered in the marketplace. Okay.
Thank you, thank you, thank you, thank you, Mariessa. This was so awesome, so helpful, and so much information that's here. Thank you also to everyone who joined us today. Thanks for folks who are watching later. As you can see, there's a lot of great information. And as you're thinking about next steps, I hope you watch this again. I hope you look at some of the resources that are on the PTO's website. Take a look at that boot camp that's right up there. And then, as Mariessa said, think about getting connected to some of the clinics or the DC Bar Pro Bono Center so that you can look for additional legal help. And so with that, I'll go ahead and wrap, but I just want to say one more big thank you for this fantastic presentation today.
Great, Kate. It's my pleasure. DC is in my blood. And so I am so happy to be able to speak to all of my neighbors today. Thank you very much for hanging in here with me after the hour.